Hello everyone. So in this particular series in which we are covering one module in one video, this video is for module B. So for your complete revision of module B, because it is very important from your exam point of view, some important acts like the Prevention of Money Laundering Act, Foreign Exchange Management Act, Payment and Settlement System Act, these acts are important and every time you will see questions. Concept based, direct, fact based questions from module B will definitely be asked in your exam. So, very carefully and very sincerely, you need to revise this particular module. We are going to cover all the units from module B in this particular video. So, let us start with the first unit of our module B. So today we have the unit 8, which is the Prevention of Money Laundering Act 2002. So this act is quite important, and the whole module B, I'd say, is very important from the exam point of view. The laws that we have, like the FEMA Act, the Negotiable Instruments Act, everything in module B is very important, right? So let us start with the Prevention of Money Laundering Act. When we talk about this act, it has no particular definition of money laundering. So let us understand what money laundering means. Basically, when you uh, indulge yourself, when someone indulges themselves in an illegal activity and they generate money out of it, but they try to show it as legal money or clean money, then it is known as money laundering. So showing the illegal money or dirty money as clean money, that is money laundering. There are various activities or acts which can be considered as money laundering, like concealment of property, showing as untainted, acquisition, possession. So what we do, people, what they acquire money from illegal activity and they try to purchase or they try to invest that money into some areas that can be shown as legal or clean money. That is money laundering. So the Prevention of Money Laundering Act of 2002 was enacted to prevent the money laundering and to provide confiscation of property. So now the authority to confiscate the property that is derived from or was involved in money laundering has been provided. So there are various chapters, various sections, various provisions that we are going to see. So let us start now. All right. So foremost, the section 3 of our act states that whoever directly or indirectly. Now let's say a person is involved in an illegal activity and they're generating money out of it, and then they do what, they transfer those receipts into an account of their relative, so that relative will also be held responsible. This is an amendment that has been made. So whoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a part or is actually involved in any process or activity connected with the proceeds of crime. All right. Let's say a person A was actually involved in a crime, like let's say drugs trafficking, and they are generating illegal money out of it, right? Then they generated this money of 20 lakhs in cash and they did what, they credited this amount to their relative relative B. All right. Now, if this person B, they know that this money had been generated illegally, then they will be equally responsible and they will be given the punishment like the jail term, imprisonment, right? But if in case they are unknown to it, they do not know that this money that is being sent to their account is generated by money laundering, then they have to inform to the authority. Only then they will be saved from the provisions of the act. So they need to inform first. This is also given in a separate provision. All right. So when we talk about the proceeds of crime, including the concealment or hiding, possession, acquisition, use, and projecting or claiming it as untainted property, shall be guilty of the offense of money laundering. So, what all is included in money laundering? If we are concealing, we are trying to hide any proceeds that are generated from an activity, we are trying to possess, let's say we are using that money, the receipts that were generated to buy a property, acquisition of property, using that money, projecting as untainted property or claiming as untainted property. And if the required authority, the enforcement directorate, they find out that this activity comes under money laundering, then they will be held guilty. All right. So now, powers of directors. There's a director which is to be appointed and they will be given certain powers. Like, because definitely banks are involved in the transfer of money. So banks have to play a separate supervisory or scrutiny role. They have to see that if any suspicious transaction is taking place from the account holder's account, like a credit or debit of a certain amount, if outside India also, right, then it is their responsibility to report. They have to conduct, if they are conducting any inquiry, they find that the reporting entity or the designated director of the board, if the if it is found that the reporting entity or the designated officer of the bank, they are not making the reports or there's some miscalculation, then they will be held responsible and a warning will be issued in writing. All right. So this is the section 3. Then we have section 4 of the act, which says that whoever commits the offense of money laundering shall be punishable with rigorous imprisonment for a term shall not be less than 3 years and can be extended to 7 years, and also shall be liable to fine. So section 4 talks about what? Section 4 talks about the punishment for money laundering, right? Now this 7 years is can also be extended to 10 years. This has been substituted, right? So the punishment is rigorous imprisonment of 3 years, which can be extended to 10 years now. All right. Then if we talk about the obligations of banking companies, the financial institutions and intermediaries, this is also important. Why? Because all the transactions are routing through the banks, the financial intermediaries. So they have the responsibility of maintenance of records. Maintenance of records of all the transactions which have been prescribed. So these responsibilities are given in the chapter 4 constituting the section 12 to section 15. So section 12 says all the transactions which are covered, which are given in the money laundering act, they have to be maintained. The record of the transactions have to be maintained. These records have to be furnished to the director within the time frame which has been prescribed, right? The records will be maintained of the clients as well as the beneficial owners. All right, so these are the obligations with the banking institutions. So which records have to be maintained? Which records have to be maintained? This is very important. All the cash transactions of value of more than 10 lakh rupees or its equivalent in foreign currency. So if any customer of the bank or if any transaction that is of the cash transaction is made and the value of this transaction is more than 10 lakh, then the record will have to be maintained. Then all the series of cash transactions which are less than 10 lakh, which are not 10 lakh, but they amount or aggregate to 10 lakh within a month. So valued below 10 lakh or its equivalent, but such transactions have taken place within a month and the monthly aggregate exceeds an amount of 10 lakh. So either one transaction is more than rupees 10 lakh or all the transactions that have taken place within a month, they aggregate exceeds the amount of rupees 10 lakh. All right. Then all the transactions where forged or counterfeit currency notes or bank notes have been used as genuine. If the person involved, they are using counterfeit notes or forged notes, where any forgery of a valuable security or a document has taken place facilitating the transactions, then also the records will be maintained and furnished. All the suspicious transactions, whether or not made in cash. Now, if the bank officers or the reporting entity, they are doubtful, they have a doubt that this person might be involved, this person has a past record of some illegal activity, so they might be involved in the money laundering activity as well. So all the suspicious transactions will also be reported, whether or not made in cash. Then all the cross border wire transfers, of more than 5 lakh rupees or their equivalent in foreign currency, whether where either the origin or destination of fund is in India. So cross-border wire transactions of more than rupees 5 lakhs and all the purchase and sale by any person of the immovable property valued at 50 lakh rupees or more. So these are the transactions wherein reporting has been made mandatory. So if the transaction is of cash of more than 10 lakh or the aggregate of all the values within a month is more than 10 lakh, suspicious transactions, counterfeit notes, cross-border immovable property valued at 50 lakh rupees. So this is very important. All of these points are important. Then if we talk about the form in which these records will be maintained, the information which is maintained, the procedure, then as per the requirements of Rule 6, the information as to the transaction should be maintained in hard and soft copies in accordance with the procedure and manner which is specified by RBI or SEBI. So when we talk about these transactions, the transactions will include the nature of the transaction, whether it is made by payment order, cashier's check, demand draft, internet transfer, or any other mode. Then the amount of the transaction and the currency in which it was denominated, whether in rupees or the equivalent foreign currency, the date on which the transaction was conducted, and the parties to the transaction. The beneficiaries details will also be included. So these information will be contained in the records. The records will be maintained in the hard as well as soft copy. Then we have the rule 8 which talks about the procedure by which the information will be furnished to the director. So the principal officer of a reporting entity shall furnish the information that we have just discussed under the rule 3 every month to the director by 15th day of the succeeding month. So if we are talking about all the transactions that are happening in the month of March, then by 15th April all of these transactions which have been given in the rule 3 will have to be furnished to the director. Then the principal officer of the reporting entity shall furnish the information promptly in writing or by fax or by electronic mail to all to respect of the clause D of rule 3 in not less than not more than 7 working days. So clause D talks about where the transactions are suspicious. Doesn't matter if the transactions are made in cash or not. If the transactions are suspicious, then within 7 working days, the report will be furnished to the director. Then the information referred to the clause F every quarter. So the clause F which talks about the immovable property. All the sale and purchase by any person of the immovable property valued at 50 lakh rupees or more will be furnished in the by the 15th day of the month succeeding the quarter. And if there is a delay in the furnishing of information, delay of each day in not reporting a transaction or dealing of each day in rectifying a misreported transaction beyond the time limit will constitute a separate violation. So it is the responsibility of the reporting entity of the principal officer that they furnish the information, they furnish the record to the director within the stipulated time. Now, what is the time period for which the records will be maintained? So, the time period is given as 5 years. The records relating to the identity of the clients shall be maintained for a period of 5 years from the date of cessation of the transactions between the client and the banking company. If the account is closed or when the transaction has happened, then from that day till 5 years, the records will be maintained. Now, why the records have to be maintained for the identity of clients? It is for the due diligence. Whenever any transaction is taking place, the verification of the identity of the clients will take place. If the client is an individual, then the certified copy of an OVD, the officially valid document with the details of the person's permanent address, current address, the nature of business, financial status will be given. If the client is a company, then the certificate of incorporation, the memorandum and articles of association, the board resolution, and the OVD in respect of the person who is opening the account. Partnership firm will require the registration certificate, partnership deed, OVD again of the person who is acting in the transaction. Similarly, trust will require the registration certificate, trust deed, and OVD, and unincorporated association will require the resolution, the power of attorney granted to the person, and the information that the bank may require. Right. So, to conduct due vigilance, due diligence, the identity of the client will be checked before the transactions. So these are the whole important provisions under the Money Laundering Act. If we go through them, so the Money Laundering Act to prevent money laundering and to provide confiscation. So if it is found out that this person was involved in the crime, they are found guilty of money laundering, then the property will be confiscated. All right. Now, who frames the laws under the Money Laundering Act? These laws are framed by the central government in consultation with RBI, right? In consultation with RBI. The central government plus RBI frames the rules under the Money Laundering Act, right? Then the director has powers to impose a fine or to take a decision, and if the director finds out that there is a misrepresentation or that the employees or the officers they have failed to comply with the obligations, then they may issue a warning in writing. They may direct the reporting entity to comply. They may direct the reporting entity to send reports at such interval which is required, or they can also levy a fine on such reporting entity, and this fine shall not be less than rupees 10,000, and it may extend to 1 lakh rupees for each failure that is made in the reporting. Right? So these are all the provisions of money laundering. Now in this we are given a summarized summarized money laundering. So the act was enacted in 2002 in response to India's global commitment, including the Vienna Convention, to combat money laundering. Salient features are there's a financial intelligence unit, there's punishment for money laundering given under the act, which can extend to 10 years plus fine, 10 years imprisonment plus fine. There's the adjudicating authority, then the burden of proof lies, and the special court. These are the various features. So, what are the powers given under the PMLA? To confiscate the property earned from the illegally gained proceeds, to appoint the adjudicating authority and appellate tribunal to deal with the matters connected with money laundering, act with the concept of reporting entity, which will include the banking company, financial institution, and intermediary. So, this reporting entity will be the banking company, financial institution, or intermediary. Then the appellate tribunal will consist of chairperson plus 2 other members, and their function will be to hear appeal against the adjudicating authority and the authorities under the PMLA. Right? Who is acting, who is mandated to enforce the PMLA? The Enforcement Directorate, which was established in 1956 and headquartered in New Delhi. All right, so this is a summarized way of the Prevention of Money Laundering Act. All right, so we have covered all the important points. Then there are certain cases pertaining to the act in which the decisions were given either in favor or against the reporting entity or against the person who was involved in money laundering. Cases like the Rose Valley money laundering case, the Galaxy Impex money laundering case. So just go through these cases so that you can have a clear understanding of the whole act. All right. Today we are going to start with this Negotiable Instruments Act, which came in March, or which was enacted in March 1882, and it presently extends to the whole of India. So this act, this law governs the making, negotiation, and the payment of the negotiable instrument, including a check and other negotiable instruments act like the bill of exchange and promissory note. Although these haven't been explained or these haven't been described in the act, but we use the same meaning of the negotiable instrument, which means a promissory note, bill of exchange, or a check, which is given in section 13. So now let us start. We are going to cover two important sections which have been introduced, section 143A and the effect of insertion on the section 148, and then we will also talk about the protection that is provided to the paying and the collecting banker. So let us start with this unit. All right. Foremost, the most important thing of this chapter is the insertion of section 143A in the Act. So with this insertion of section 143A, what changes have been made? This new provision was introduced wherein a competent court, while trying a check dishonor offense, is empowered to order the drawer of the check to pay interim compensation not exceeding 20% of the check amount to the complainant, where the drawer pleads not guilty to the accusation. So dishonor of the check. In the check which is signed in the name of the drawer and the drawee is responsible to pay for it, if the person on whose account the check is written, if they do not have sufficient fund, then we will say that the check has been dishonored. All right, that it has been dishonored. When such person says that no, I did have the sufficient fund and they plead not guilty on a complaint that was made, then for that, this section 143A says that first you need to pay a 20% of the amount which is given in the check, right? This is the compensation which will be stated by the competent court, that this is the compensation, and 20% of the check amount will be paid to the complainant, and then the case will be taken further. This is given in the section 143A. Further, it also states that this compensation, this interim compensation, has to be paid within a prescribed time period of 60 days from the date of passing of the order by the court, and then it can be extended to 30 days if significant cause for the delay has been provided to the court. All right, so first thing, that whenever here the check dishonor offense is brought to the court, then the appeal can be laid that the dishonor was not there, and here the order will be given to the drawer of the check to pay the interim compensation not exceeding 20% of the check amount, where the drawer says that they are not guilty of the accusation made in the complaint. So this is given in the section 143A. So what is the effect of this insertion of section 143A? Through, so the amendment was inserted through section 148, that in the case of an appeal which is filed by the drawer against the conviction under section 138, so the bank, they can file the case of dishonor with the court, but the drawer then says that they are not guilty. So now what will happen under section 148? Then the appellate court may order the appellant to deposit such sum which shall be minimum 20% of the fine or the total compensation which is awarded by the trial court. So for the appeal to be taken further, first the appellant will have to deposit 20% of the compensation which is awarded by the court. Then it will be taken further. So this is given, or this is the change that has been made with the insertion of section 143A. Right. Then if we talk about the negotiable instruments, their types and characters. So this is given in section 13 of the Act. Section 13 of the Act, that negotiable instrument will mean a promissory note, a bill of exchange, or a check which is payable either to order or to bearer. So either an order check or a bearer check will be treated as a negotiable instrument, right? Then the basic characteristics, there's a contract between two or more persons in a negotiable instrument. Then this, it should be in writing, it should be in a expressed in a particular currency, Same things that we already know about the negotiable instruments. So there are presumptions as to the negotiable instruments, which are given in section 118 and 119. The presumptions of consideration as to the date, as to the time of acceptance, the time of transfer, that the holder is a holder in due course, right? We will see what is the meaning of holder in due course. These are the things. Now, when we talk about these instruments, so I have put them in a chart wherein the difference between promissory note and a bill of exchange is given. Promissory note is where there are only two parties, maker or the debtor of the promissory note and the payee or the creditor of the promissory note. It contains an unconditional promise by the maker to pay the payee, and here no prior acceptance is needed. The liability of the maker or the drawer is primary and it's absolute, and no notice of dishonor need be given. These are the characteristics of a promissory note, where we promise to pay the payee certain amount. Then we have the bill of exchange, where there are three parties: the drawer, the drawee, and the payee. The drawer, the drawee, and the payee. It does contain an unconditional order to the drawee to pay according to the drawer's directions, and the bill payable after sight must be accepted. In the promissory note, prior acceptance is not needed, but in a bill of exchange, the prior acceptance is needed before it is presented for payment. The liability of the drawer is secondary and conditional upon the non-payment. And finally, the notice of dishonor must be given by the holder to the drawer and intermediate endorsers to hold them liable thereon. Right? So these are the basic characteristics or basic difference between promissory note and a bill of exchange. Then we also have the difference between a check and a bill of exchange. Check can be drawn only on one banker, only on a banker. But the bill of exchange can be drawn on any person, including a banker. Check is drawn only on a banker, right? The amount is always payable on demand in a check, and check is not entitled to the days of grace. Here, acceptance is not needed, and check can be crossed if required. The notice of dishonor is not necessary. It is not to be noted or protested, and protection is given to the paying banker. This is very important. Where the protection will be given to a paying banker in the case of check, where let's say there is a material alteration which is not apparent. We will see the provisions related to it. So the protection will be given to the paying banker as well. Under which section we will see. So now for the negotiable instruments, we see that there are certain terms, like the drawer is the maker of the negotiable instrument or the bill of exchange. So these terms, I hope you are familiar with the terms. Drawer is the maker of the bill of exchange, right, or the check, and person who is directed to pay is known as the drawee. Directed to pay. Directed to pay is the drawee. Then drawee in case of need will be a third person which will be resorted to if the drawee, if the need arises, right? If there is any endorsement, so that is the drawee in case of need. Acceptor will be that after the bill has been signed, or if there are more parts, all of them have signed to it, then any person who is the holder on behalf is known as the acceptor. Then acceptor for honor is there, and payee is the person who is directed to be paid. So payee is the person who is to get paid. These are the three main terms: the drawer, drawee, and payee. Then we have the drawer in case of need, acceptor for honor, and the acceptor, right? Then if we talk about the payment of checks, so there is certain protection that is provided to bankers as well as the customers, right? So first we have the banker's duty to pay, which is given in section 31 of the Act. The drawee of the check that is having sufficient funds of the drawer in his hands properly applicable to the payment of such check must pay the check when duly required to do so. So this is the duty of the banker to pay the check if the drawer has sufficient funds in their account. Everything is according to the provisions. the amount is mentioned, it is signed, and it is a legal contract, then they, and also if there is any default in such payment, then they must compensate the drawer for any loss or damage that is caused. Then payment in due course. If the payment is done in due course, if the check is made in due course, then the paying banker will be provided protection. If let's say the banker had taken all the necessary precautions, due diligence, they had seen the apparent tenor, they had seen the person was in the rightful possession of the instrument, but anything because of any material alteration that was not apparent, it was not the fault of the bank, then they will be provided protection. Protection will be provided in terms of section 85. Section 85, against fraudulent endorsements of the payee or other endorsees, right? So in terms of section 85 of the act, protection is provided to the paying banker against fraudulent endorsements of the payee or other endorsees in an order or bearer check, right? If the payment is made by the banker in due course, that it was not very clear that the changes that were made, they were against the provisions of the act, right? So the bank had taken due care, they had used all the preventive measures, all the vigilance, then also any fraudulent activity has occurred, then the bank will be provided additional protection, right? So the conditions that are to be fulfilled for protection, right? So that there was no doubt that the payment of the check had any question, right? It was accordance with the apparent tenor, then the check was not crossed and payable to the plaintiff or the order, right? Payment was made in good faith and without any negligence. All of these things, if they are seen, then protection will be provided to the banker. Now, when we talk about material alteration, let's say we have a check in this form and it is in the name of a person, let's say X, Mr. X. If what happens, the amount which is mentioned here is 20,000, and the person does what? They fraudulently, without informing the bank or without informing the drawer, they do what? They add a zero to it. Now here it wasn't cancelled or it wasn't marked, so zero adding, and it is not apparent to the banker, right? But it is a very substantial alteration that has been made. Or this person X name is changed to Z. This is also a material alteration. So whenever any alteration substantially alters the instrument, it substantially alters the instrument and it is without the knowledge of all the parties involved, then irrespective of whether the alteration is beneficial or prejudicial, it will be known as a material alteration, and it will be termed as a fraudulent activity. So alteration in the date of the instrument, alteration in the name of the payee or the beneficiary, alteration of the amount, which is the most common type of fraudulent alteration, alteration of an order check to a bearer check. If anything is done without the knowledge of the other parties or the bank, then it will be a fraudulent transaction or a material alteration, right? Now, section 89 says that where payment is made by the bank on presentation of an instrument which is forced by alterations which are not apparent, which are not visible, which are not clear to the naked eye. If a check is an electronic image of a truncated check, then any difference in the apparent tenure of such electronic image should be considered as a material alteration. And it will be the duty of the bank to cancel the check, to not make the payment if there is any change, if they're even suspicious of it, right? So any bank, they, if they receive any image or it is different from the original, then they need to cancel it out. All right. So then section 89 says that if any change is seen as from the naked eye that it has been altered, the check has been altered, then it is to be treated as void, erroneous or fraudulent alteration, right? It should be visible to the naked eye. Now, there were many cases in which court decisions were taken in favor of the bank, wherein the material alteration was not apparent, right? And the banks were given protection. Now, what is the protection that is provided to the collecting bank? To the collecting bank, there are certain terms that we need to know first. First, we have the holder. Section 8 says that to be a holder of an instrument, the person should be entitled in her or his own name to the possession. If you find a check lying down on the road anywhere and you take it to the bank, you will not be known as the holder. All right, so that holder, you should be entitled, the instrument should be in your name, to the possession of the instrument or to receive or recover the amount, which implies that the holder does not include a person who through a possession of the instrument has not the right to recover the amount of the instrument. So you should be entitled to the instrument, right? This is given in section 8 of the NI Act. Then holder in due course, this is given in section 9. Holder in due course means any person who for consideration becomes a possessor of a promissory note. Consideration, which is a two-way contract. So if for consideration they become the possessor of a promissory note, bill of exchange or check, if payable to the bearer or the payee or endorsee, or if payable to the order, then the amount mentioned in it becomes payable and without having sufficient cause to believe that any defect existed. Alright, so for consideration, if the instrument is passed on to another person for the same amount that is to be paid, then it will not be considered void. So that person will be known as the holder in due course or in the right manner. That is given in section 9 of the Act. Then we have the holder for value. So when a bank, to oblige a customer for any reason, they pay the amount of the check drawn for on another bank before its collection, then the possession of the bank who is paying the customer is the holder for value. So the bank who is obliging the customer, they are paying the amount of the check that is drawn on another bank before its collection. They will become the holder for value. Now, when we talk about the law that provides protection to the collecting bank, so the protection to the collecting bank is provided in section 131 of the Act. According to this, a banker who has in good faith without negligence received payment for a customer of a check that was crossed generally or specially to himself, in case the title of the check proves to be defective later on, they may incur any liability to the true owner of the check by reason of only having received such payment. So if a banker, they have made the payment in good faith and without any negligence, then they shall not incur any liability if later on the check is found to be fraudulent, right? If it is later on found to be fraudulent. So this basis of protection is only for the cross check, and statutory protection is available to the collecting bank only for the cross check, right? Not where the drawer signatures are forged. So they need to make sure that the drawer signatures are correct, and then collection should be done in good faith and without any negligence. Collection should be done on behalf of the customer only. Verification of the genuineness should be done. So the if the electronic image of a truncated check is received, then the bank should have verified the apparent genuineness. They need to make sure that all the information that is given is correct. Further, if there is a dishonor for the check of insufficiency, let's say, in that case, the section 138 provides for the provision, right? So where any check is drawn by a person on an account that is maintained by him, but it is returned unpaid by the bank because of there is insufficient money in the account, then it is punishable. That person, they can be punished with the imprisonment for a term which may be extended to 2 years or a fine or even both. All right. So the check has been presented within the due time, within the due tenure, but it has been dishonored. So section 139 says that the presumption in favor of the holder will be there. Section 141 says that offense when it is conducted, then it will be punishable. All right. And then we have already seen the procedure under section 143A, which has been inserted, that under the Code of Criminal Procedure, the court is going to take the offense. All right. So these are all the important points regarding the Negotiable Instruments Act. So you need to remember the compensation which will be paid by the appellant under section 143A, then the amount it will be deposited within 60 days from the date of the order. Higher appeal also lies, but not beyond that. So these are the basic main provisions. So today we are going to start with the FEMA Act, or the Foreign Exchange Management Act. If we talk about a bit of history, so earlier to the FEMA Act 1999, the FERA Act was governing the foreign exchange. It was the Foreign Exchange Regulation Act. So it was the Foreign Exchange Regulation Act, FERA, which came in the year 1973. But it was felt that this act was quite stringent, and it came in the way of making India more liberalized, which was the aim for a more globalization developed economy. So this was repealed. Why it was felt? Because it was too rigorous and had outlived its utility. So it was replaced by the FEMA Act in 1999, and its aim was to consolidate and amend the law relating to the foreign exchange and objective of facilitating external trade and payments. The most important point. The Foreign Exchange Regulation Act was regulating it or controlling it. There were a lot of controls, restrictions on the foreign exchange, on the FDI and FPI. These were made flexible, these were made easy with the FEMA Act to facilitate the external trade and payment, and for promoting the orderly development and maintenance of foreign exchange market in India, consequent to the globalization and liberalization with the LPG reforms of 1991. Plus, there were various other issues like the current account convertibility was not there, and our foreign exchange reserves were fast depleting, because of which the Narasimham committee uh, and various other committees, they gave their recommendations, right? And the LPG reforms, with that the FEMA Act was also enacted. Now in this chapter we are going to see the various provisions of the act, which extends to all over India. Now there are certain terms, important terms, which are used in the act, like the authorized person means any authorized money changer or dealer, offshore banking unit, or any other person which is authorized under FEMA to deal in the foreign exchange and securities. The FEMA Act says that no person can directly involve or exchange the foreign exchange without the involvement of the authorized person. We will see whether this authorized person, who is this entity who appoints the authorized person, who has the rights for the supervision and control. So any authorized person, the money changer or dealer, who are given the authorization to deal in foreign exchange or securities. Then two important concepts, the capital account transaction and the current account transactions. One thing that will make the definition or meaning of both of them clear: capital account transaction, where the asset or liability situation of the nation changes, and current account transactions, where there is no change in the asset or liability. This is the only thing that you need to remember from here. Capital account transaction, any transaction by which there may be a change, either an increase or decrease in the assets or liabilities outside India of the persons resident in India, or assets or liabilities in India of the persons resident outside India. If any change is happening in the asset or liability situation, then it is a capital account transaction. And current account transaction, wherein no change occurs, like payment which is done in the ordinary course of business of services, short-term banking, then interest and loans, income from investment, then remittances from people who are living abroad or remittances out of India, expenses in connection with foreign travel, education, all of these. Then there are certain other terms like currency. It includes all the currency notes, postal notes, money orders, checks, drafts, anything that may be notified by RBI. Foreign currency refers to any currency other than India. Foreign exchange means when we exchange one currency to another, like what is the value of $1 in rupees, whatever the current amount is, that is foreign exchange. The amounts that are payable in foreign currency. Then security, the regular meaning of security, like the shares, stocks, bonds, debentures, right? Then important thing is the person resident in India. There's a very huge difference between a citizen of India and a person resident of India. And the FEMA Act is only concerned with the person resident in India. So you need not worry about whether the person is a citizen or not. They should be a resident of India, and then the provisions of FEMA will apply accordingly. So any person who is residing in India for more than 182 days in the preceding financial year and their economic interest is in India, they're residing in 182 days. Plus, they can be any person or body corporate which is registered or incorporated in India. It can be situated outside India. Then any office, branch or agency owned and controlled by a person resident outside India. So, person resident outside India, but they're controlling office, branch or agency in India. And any office, branch or agency which is outside India, but it is controlled by a person resident in India. So when we talk about a person resident in India, it is going to include, let us say it is not going to include any person who goes out of India for taking employment outside India, or carrying any business or vacation outside India, vocation, right? Then any person, if they're coming to India, although they are staying for more than 182 days, but their economic interest is not in India. Like for, let's say they are coming here to travel for visiting, right? So they will not be included as a resident. They will be included as a resident who come to India, stay in India for taking up employment or any business or anything which is accepted by the government, right? So any person who is resident outside India means any person who is not resident in India, NRI. These are the definitions given under the Act. Then if we talk about the regulation and management, so no person shall, which is given in chapter 2 section 3, says that no person shall deal in or transfer any foreign exchange or foreign security to any person not being an authorized person. All right, so only this foreign exchange can happen, dealing or transfer of foreign exchange through the authorized person. Then they cannot make any payment or credit of any person resident outside in any manner. Make, they can receive otherwise to an authorized person any payment or by order, or they can enter into any financial transaction. So these regulations says that the transactions, transfer, payment, everything should be in accordance with the FEMA Act, and this is given in the chapter 2 section 3. Otherwise penalties will be imposed, right? So if a person who is resident in India and they're receiving any payment on order or on behalf of any other person, then it should be through the authorized person only. So this is the meaning of the statute or the provisions given in the FEMA Act. Now when we are talking about these authorized persons, so who has the power to appoint these authorized person or to inspect these authorized person? This is with RBI. So RBI is going to appoint the authorized persons who are going to deal in foreign exchange, plus the inspection will be also conducted by RBI from time to time. Then another important provision when we talk about is the penalty. So the penalties, including the right of arrest and detention, is given under section 13 of the Act. Very important. The FEMA Act says that if there is any violation of the provisions of the Act, or any rules or regulations or contravention is there or anything, then this person, when we talk about the penalty, then this person will be liable to a penalty up to thrice the sum involved in such contravention where the amount is quantifiable. If the amount is quantifiable, it can be calculated, then thrice the amount involved will be imposed as the penalty, or up to 2 lakh rupees where the amount is not quantifiable. So both the terms are important. When quantifiable, thrice the amount; not quantifiable, up to 2 lakhs will be the penalty. Plus, if the contravention is of a continuing nature, not once, but it is continuing, going on for many days, then this penalty may extend to 5,000 rupees for every day after the first day during the contravention continues. So, this penalty will be increased. If it is of a continuing nature, it will be increased and it will be imposed on every day. That can extend to 5,000 rupees. Alright. So this is the first provision under section 13. Then if we talk about immovable property, if any person is acquiring immovable property outside of India of the aggregate value exceeding the threshold which is prescribed, very important, these penalties or these arrests will not be imposed if the amount which is aggregated is not more than the threshold. So the persons, people in India, outside India, they can participate in foreign exchange, and the penalties or law will be applied only if it is beyond the maximum limit. Right? So let us come back to the provision. It says that if any person is said to have acquired any foreign exchange, foreign security or immovable property exceeding the threshold limit, then the penalty will be up to 3 times the sum involved. Plus, when we are talking about immovable property, so let's say a house has been acquired by a person in Japan and it is beyond the threshold level, then confiscation of the property of the same value will be done in India. So if this person who has acquired the property in Japan, they also have a property in, let's say, Gujarat. So the property in Gujarat will be confiscated by the government of India. This is also a provision, right, related to the immovable property. Then if the adjudicating authority, only when we talk about the cognizance of the cases, when will the court accept the cases, it will be done only when the adjudicating authority, they are recording the reasons in writing. They may recommend for the initiation of prosecution. And then if the director of enforcement, this is a body which is appointed by the central government to foresee the enforcement and working of the FEMA provisions. And then when the adjudicating authority, they with the reasons in writing, they recommend the initiation of prosecution. And if the director of enforcement is satisfied, then they may direct the prosecution by filing a criminal complaint against the guilty person by an officer not below the rank of assistant director. So 3 points are given here. First, the complaint will be given in writing with the reasons, by whom? By the adjudicating authority. Then the director of enforcement is going to take cognizance of the complaint that has been filed against the guilty person, and then they will be filing a criminal complaint, and this criminal complaint will be filed by an officer not below the rank of assistant director, not below the rank of assistant director. So 3 important points are given regarding the adjudication. And obviously, like any other statute, there's also the right to appeal, the right to appeal, right? So if any person is aggrieved by the appellate order, then they can appeal against the order before the appellate tribunals which are established for this purpose, right? So this is there, which we have already seen. If any person is found to have acquired foreign exchange, foreign security, movable property situated outside of India of the value exceeding the threshold prescribed, then penalty will be imposed, as we have seen, thrice the amount or 2 lakhs rupees or of the continuing offense. Plus, they will be punishable with the imprisonment for a term which may extend to 5 years with fine. Why? Because it is a criminal complaint which will be filed. So the criminal complaint is going to raise a imprisonment term as well, which may extend to 5 years. Then no court, we have already seen, shall take the cognizance of an offence of section 13 except as on the complaint which is given by a writing by an officer not below the rank of assistant director. All right, written complaint made by the adjudicating authority, and this officer should not be below the rank of assistant director. All right. So then we mentioned the term Directorate of Enforcement. Who establishes the Directorate of Enforcement? The central government, with a director and other officers called the officers of enforcement. This Directorate of Enforcement and the other officers of enforcement, again, they should not be below the rank of an assistant director. They can investigate the contraventions of the FEMA Act, as well as they will see the enforcement of the rules and regulations which are framed, including the notifications or directions or orders which are issued by RBI. If let's say RBI has issued the order of inspection or any change in the provisions, so the Directorate of Enforcement will make sure that the provisions are adhered to, and this Directorate of Enforcement is appointed under section 36, right, under section 36. Then the central government may also authorize any class of officers in the central government or the state government or even RBI not below the rank of an under secretary. Under secretary. Why? To look into the investigations, to investigate the contraventions. This is given under section 37. So section 36 talks about the Directorate of Enforcement not below the assistant director level. But if the central government finds fit, they can also appoint under secretary level officers from the state government, central government, or RBI, right? So now the central government can authorize any customs officer or the central excise officer, any police officer to exercise the powers and discharge the duties which is given in the section 38. So three sections deal with the Directorate of Enforcement. Section 36, section 37 and section 38. Right? Now when we say that the case reaches the competent court, there should be a time limit within which the case should be disposed of or the order should be given along with the fine and the imprisonment term, right? So the competent authority shall dispose of the petition within a period of 180 days from the date of seizure by either confirming or by setting aside such order after giving an opportunity of being heard to the representatives of the Directorate of Enforcement and the aggrieved person. We said that every person, they have a right to appeal, right? So even here the aggrieved person, they can have the right to appeal if under the provisions the central government have let's say confiscated the property. So the aggrieved person can go to the uh, court and they can make an appeal against the decision, and the competent court will give their order within a period of 180 days, right? So reasons should be given in writing, then the court will give the order, they can seize the value equivalent which is situated in India, and all of these provisions that have already been discussed. And the order of seizure, when we talk about, with the relevant material, will be placed before the competent authority appointed by the central government, and they shall not be below the rank of the joint secretary, and this will be done within a period of 30 days from the order of the seizure, from the date of such seizure, and any petition will be disposed of within a period of 180 days. All right. Yes. And finally, if any person is aggrieved by an order which is passed by the competent authority, then they may prefer an appeal to the appellate tribunal, which is again designed or set up for the particular purpose. Payment and Settlement Systems Act of 2007. Now let us start with this act, which is the Payment and Settlement Act. Basically, this act came to monitor and supervise or regulate the payment systems in India, and it also designates the RBI as the authority for that purpose and all the related matters. So whenever we make an online payment, we refer to that as a settlement which was made using the payment system. All right. So before the digitization or before the electronic banking, these systems did not exist. But with the advent, and today more so, all the transactions, maximum transactions are routed through the payment system. So it is very important to regulate and supervise these payment systems. So when we talk about the Payment and Settlement Systems Act of 2007, it came into effect on 12th August 2008, and it extends to the whole of India. Now, who has the responsibility for the regulation and supervision? It is the RBI. The Reserve Bank is authorized under the Act to constitute a committee of its central board. We will see the members of the central board in the further slides. But RBI has the power to monitor and supervise, and RBI has the power to constitute a board which is known as the Board for Regulation and Supervision of Payment and Settlement Systems, the BPSS. And this board is going to exercise its powers and perform its functions and discharge its duties under the statute. So RBI indirectly through the BPSS supervises and controls and regulates the payments and settlement system. So in this act, we are going to talk about the authorization for any payment system to work, the issuer. We will also talk if there are any changes that are to be made that also require approval from RBI. Any penalties if are imposed. Everything is covered under this act. The first important section is section 2, subsection 1 and subsection 2. The section 2 of the act defines important terms like the bank, included in the second schedule of Reserve Bank, any cooperative bank, a banking company, a post office savings bank, the regular definition that we have. Then definition of derivative is given, which is an instrument which has a derived value which will be settled on a future date. What is the meaning of the electronic funds transfer, wherein the transfer are made through the electronic means and includes the point of sale transfers, ATM transactions, transfers initiated by telephone, internet, any card payment, right? Then we have the meaning of settlement, gross settlement, net settlement. These definitions are given. Then the section 2, subsection 2 talks about the terms which are not defined in the subsection 1. These terms will have the same meaning, the words and expressions will have the same meaning as defined in the RBI Act or the Banking Regulation Act. They shall have the same meanings that are assigned in these two acts. Alright, so here I have included a few important definitions like what is the gross settlement system. It means a payment system in which each settlement of funds or the securities occurs on the basis of separate or individual instructions. Each settlement, right? Separate or individual instructions. So every person or every transaction that is made, it is settled separately. The settlement is done separately. It is a gross settlement. It is opposed to the net settlement where an aggregate is made. We will see in the further slide. Then issuer means any person who issues a legal identity identifier, the legal entity identifier, or such unique identification as may be specified from RBI from time to time. So any person who issues a legal entity identifier. For every transaction, there will be this legal entity identifier or any unique identification. What does this mean? It means a unique identity code assigned to a person by an issuer for the purpose of identifying such person in any derivatives or financial transactions. So it is a unique identity code which is given, and whenever you make any payment using the electronic mode or the payment system, this legal entity identifier will be used. So we have seen the gross settlement. We also have the net settlement or netting. What is the meaning of netting? Netting means the determination by the system provider for the amount of money or securities as a result of setting off or adjusting the payment obligations, right? Either they set off or adjust the payment obligations, including the claims and obligations arising out of the termination of the system provider, the insolvency or dissolution or winding up of the system participant, or any other circumstance. So what we are doing, either we are setting off, we are cancelling, or we are adjusting any debit and any credit. Any debit is adjusted for any credit. This is the meaning of netting. Alright, netting means the setting off or adjusting. So this is the term that you need to remember. Alright, then this is section 2, which talks about the various definitions. Apart from that, what is the meaning of the payment instruction, payment obligation, payment system, system participant, trade repository, all of these terms are also given. Then if we talk about the designated authority, I've already told you the designated authority is the RBI for the supervision of payments, anything, and it is dealt with in section 3 of the Act. In section 3 of the Act, right? So we said that the Board for Payments and Settlement System, the BPSS, shall consist of the following members. RBI is the designated authority for the regulation and supervision to perform the functions and discharge the duties. The board that is set up by RBI will consist of members. The governor of the RBI will be the chairperson. The deputy governor of the RBI will be the in charge of the payment and settlement systems. The officer from the Reserve Bank, one officer to be nominated by the central government to be the ex officio member. So the central government is going to nominate one officer from the Reserve Bank to act as an ex officio member, and three other persons are to be nominated by the central government to be the members. So apart from the RBI governor, deputy governor, one officer and three other persons will be nominated by the central government. These are going to be the members of the regulatory board. Then the powers are given in the section 2, the time and venue of the meeting, the procedures, everything has been prescribed. Now the section 4 is another important section. The section 4 of the Act says that no person other than the Reserve Bank shall commence or operate a payment system. All right. So whenever a new company or any issuer, they want to start a payment system, a new company wants to set up a payment system, they need to get approval from RBI. Authorization will be made under the powers given to RBI. So the continued operation of an existing payment system before the commencement of this act, they also need to take authorization not exceeding 6 months. So if a payment system was existing before the act was commenced, so within 6 months of the enactment, they have to take authorization from RBI, or it can also be refused. The RBI will check the necessary conditions, the paid up capital, the technology, requirements, everything. And if they find that these are fine, then they can give the authorization or they can give the refusal, right? So this is there. So any person or organization who want to commence operation of a payment system, they have to apply for authorization with RBI. So applying for the authorization, section 5. Then scrutiny and inquiry by RBI, section 6, and authorization or refusal is given by RBI in section 7. So three important sections, section 5, section 6 and section 7. 5 says that any person or organization, if they want to start a payment system, first they need to apply for authorization. That they will do in section 5. Then section 6, the RBI will conduct scrutiny or inquiry, and on the basis of their scrutiny, they will authorize or refuse the application. All right. So the scrutiny that we are talking about in section 6, RBI will check various things like what is the financial status, the technical status, which are required for operating a payment system, the terms and conditions of operation, the manner in which the transfer of funds may be effected, the monetary and credit policies, right? Then, when the authorization form is being submitted, the date on which the it will start effect, it will take effect, the conditions to which the authorization shall be enforced, the payment of fees, if any, that is done, has to be mentioned, right? If any security has been furnished, or the time period for which the authorization will be continued or it will be revoked, everything will be given by RBI along with the authorization. And whenever the authorization is refused, it shall also give the applicant a notice giving or stating the reasons for the refusal. And again, the application, the aggrieved service provider, they may appeal to the central government if the refusal is made by RBI. This appeal provision is also there, right? Then section 11 talks about the rules for changes. Now, if a payment system is operating in a certain manner and they want to make a change, so for that, two things need to be done. First, no system provider shall cause any change in the system which would affect the structure or operation of the payment system without prior approval of RBI. So if any change is going to affect the structure or operation, because the public are using that payment system, if any change is made, then this change can be detrimental. So RBI has said that any changes that are to be made, first they require prior approval. Second, by giving notice of not less than 30 days to the system participants. So system participants are the users. So whenever RBI gives an approval for any change, from that date, 30 days notice will be given to the system participants before implementation of the changes. Alright, so these are the two things regarding the rules for changes given in section 11. Then section 12, 13 and 14 talks about RBI's powers to conduct returns or access information, carry out inspections of any payment system and the premises. So RBI, they can designate any officer to visit the payment system from wherever they are functioning to conduct their inspection, right? They have this power. RBI can also ask for any information from any system provider, any such returns or documents, or at any interval that they require. They can access information relating to the operation of the payment system, and also they may authorize an officer who might visit the premises. They can enter any premises without prior notice being given where the payment system is being operated. They may inspect any equipment like the computer system, document. They can ask any employee to give information, right? They can ask to furnish information or documents as may be required by the officer. So these are the provisions for the information and inspection given in section 12, 13 and 14. So RBI can carry out the audit and inspections of the payment systems as well as the participants. Then once RBI has given the authorization, and if they find out during their inspection that the payment system is not working according to the terms and conditions, or any activity which is detrimental to the public, if any activity is undertaken, then they can revoke the authorization at any time on happening of certain events in which is given in section 8 of the statute. So once RBI gives the authorization, they can also take away or they can revoke the authorization under section 8 of the act. Alright. So now if any person is aggrieved by this refusal or revocation of the authorization, they can make an appeal to whom? To the central government. Very important. Appeals questions are very commonly asked. So the aggrieved service provider may appeal to the central government against the revocation of the authorization within 30 days from the date on which the order is communicated to them. So if RBI, they refuses the application, right, then the appeal can be made. Appeal can also be made if RBI has revoked the authorization under Section 8 of the Act, and this has to be done within 30 days. Now, the central government will try to dispose of an appeal under a period of 3 months. Moreover, the decision which is taken by the central government on the appeal shall be final. No further appeal lies with any court. So once the central government takes a decision, they can direct the RBI to take back their decision, or they can say to the service provider that this decision taken by RBI was correct and you should stop all your operations now. Alright, so the decision of the central government on the appeal shall be final. And if we talk about the refusal, every application has to be processed by RBI as soon as possible, and any such application should be disposed of within a period of 6 months from filing such application. So the time periods, the time limits have been given. Then we talk about the settlement. What is the meaning of settlement and netting? So the definition of settlement is also given in the section 2 of the Act. Settlement means wherever the settlement it takes place, whether it is taking place at the gross or the net basis. Settlement means the process of transferring of the funds through the central agency, or we can say from the payer to the payee. So when the transfer instruction is given, the payment instruction is given, and it is completed, the transferring of funds through the central agency from the payer to the payee, then it is known as a settlement. Alright, now gross settlement we have already seen. It is done on a one-on-one basis or one-to-one or individual basis, right? So every transaction will be done on individual basis. That is without bunching with other transactions. We have seen the RTGS, NEFT payment systems that are working, right? So the gross settlement means without bunching with other transactions, or by not netting the receipts and payments between the two parties. So neither we are bunching them together nor we are netting the payments. That is a gross settlement. Net settlement, however, is a system in which large number of transactions between the counterparties are accumulated. Let's say party A and party B. First, a credit transaction was initiated from A to B. Then again, a debit transaction was initiated from B to A. Again, a credit transaction from A to B. Again, a debit transaction from B to A. So what will happen? Large number of transactions between two counterparties are accumulated. They are collected and offset against each other, with only the net differential being transferred at the predetermined times. So what is happening here? Now, if let's say that all the transactions, let's say 4 credit transactions and 3 debit transactions. Credit transactions amounting total of rupees 15,000. We are taking just a small number, and all the debit transactions from this side amounting rupees 10,000. These will be offset and only the payment will be made of the remaining 5,000. So this is a set off which is done in the net settlement. So what is being done? A large number of transactions between the counterparties are accumulated and offset against each other, with only the net differential being transferred at the predetermined time period. Alright, so I hope this is clear, the meaning of settlement, gross settlement and net settlement. And apart from that, any other important provisions? So whenever any settlement is made, whether gross or net, it should be made very clear that these settlements are final and irrevocable. These settlements are final and irrevocable. These cannot be taken back. Alright. So it has been given in the provisions not to reopen any determination that has become final or irrevocable. Right. After appropriating according to the rules, regulations of the bylaws, everything, no return of the collateral or anything will be done. So Any settlement which is made, whether gross or net, it is referred or it is said to be final and irrevocable, as the money, securities, or the foreign exchange or any other transactions, the settlement has already been done, right? Then RBI also has powers to make regulations as to how the system providers, the banks, or the countervening provisions, anything. All the regulations are made by RBI under section 30 and 31 of the Act. Plus, regulations are also given under section 38. So, the powers and functions refer to the board, the form and manner in which an application for the authorization will be submitted, then the authorization will be issued, under which format, any regulation which is made, everything. So, RBI is the designated authority. So today we are going to start with the unit 13 of module B, which is the laws relating to securities and mode of charge, part 2. So let us begin. First type we have appropriation. Simply if we try to understand appropriation, if let's say one borrower has taken multiple loans from one creditor, let's say a bank. All right. And when they make a payment, let's say loans were taken of rupees 1 lakh, then another loan that was taken of rupees. Then in another year, we say the loan that was taken of 1 lakh rupees was in the year 2015. Then in 2016, another loan was taken of rupees 2 lakhs. Then 3 lakhs loan was taken in the year 2017. So here the same borrower and same creditor are entering into these agreement. Now if this borrower makes a payment of rupees 2 lakhs of rupees 2 lakhs or let's say 1 lakh in the year 2018. Now they will have to state to which of these three loans will the amount that is paid will be appropriated. That is the process of appropriation. All right. So if the borrower is stating that use this amount to make the payment of the first loan, it is the appropriation made by the borrower. If they're not making any intimation about this, then the creditor can on their own discretion make the appropriation accordingly. And if none of these or neither the creditor nor the borrower are making the intimation, then it will be by law. It will be by law, and proportionately the loans will be appropriated. So now we see the formal definition. So in law, where a debtor and a creditor are involved, appropriation is the application of a particular payment received from a debtor for the purpose of repayment of a particular debt. So the debtor or the borrower, they are stating that use the payment to make the repayment of a particular debt. In other words, it is the setting aside of funds. This is the meaning of appropriation. Now, there are three important sections under appropriation: 59, 60, and 61. Section 59 says where a debtor owing several distinct debts to a person makes payment to him, either with express intimation or implying that the payment is to be applied to the discharge of some particular debt, then the creditor has to accept it. The payment should be accepted and must be applied accordingly. So the first priority of making the implication or intimation for the appropriation lies with the debtor, right? Then if the debtor has omitted to intimate, or there is no condition that states that the payment has to be made in a particular discharge of a particular debt, then the creditor may apply it at his own discretion. All right, so section 60 says discretion with the creditor only if the debtor has not stated any particular debt to be paid off. Now, this is whether or not it is barred by the law in force at the time of being to the limitation of suits. So, when the creditor is using their discretion, they will try to pay off a debt that has that is close to the time bar, right? or that has a lower rate of interest, or when a debtor is trying to pay off a debt, they will pay off a debt that has a higher rate of interest, right? Similarly, they will use their discretion. If none of them make the appropriation, if neither party makes an appropriation, then the payment shall be applied in discharge of the debts in order of time. In the order of time. So the law will apply here if neither the creditor nor the debtor are making any appropriation. Whether they are or not barred by the law for the time being in force, the payment shall be applied in the discharge of each proportionately. All right, so either in section 59, discretion of the creditor, discretion of the debtor, section 60, discretion of the creditor, and section 61 talks about the law when neither party makes an appropriation. This is the charge of appropriation between the creditor and the debtor. Then we have the assignment. Assignment, the most popular example of assignment is where the loans are taken on the insurance deeds. The insurance deeds. So if a person is keeping the insurance paper or the insurance deed for, let's say, a house loan, a housing loan was taken and insurance on the house was given as the mortgage, or it was given as a security, not mortgage but security. All right. So if here the borrower and the creditor is there, the borrower will say, if I fail to repay or there is a default in the payment, then the proceeds can be generated from the insurance company or the insurance paper or contract. All right. Another example of assignment is where three persons are involved. Three persons are involved, and the contract is between two people, but a third person is transferred the rights to make the payment. So here the transferor and the transferee, or the assigner and the assignee relationship will exist. So assignment means the process by which a person called the assigner prefers to transfer rights or benefits to another person called the assignee. However, there can be no transfer of duty, burden, or any other detriment without the express agreement of the assignee under assignment. So the assignee to whom the transfer of rights is being made, they should have the express agreement to it. And only the assignee can have only the rights equal to that of the assigner and cannot have better rights. This is another important point. All right, this is another important point. Another example of assignment can be if, let's say, A owes a debt to B and B owes a debt to C. So B can say that A, you make directly payment to C. So that is also a type of transfer of the rights. All right, this is there. Then the third type is a pledge. A pledge. Pledge is a relationship which exists between the pawner and the pawnee. The person who is bailing their goods. Pledge basically means the bailment of goods for the purpose of providing security for a payment of debt or performance of promise. In bailment, what is happening? The goods are transferred for use for a particular period and then they are returned. In pledge, what is happening? The goods are bailed but to be kept as security. For example, when the borrower goes to the lender, a bank, and asks for a loan, the loan is advanced in returns of the pledged goods. So the possession of the pledged goods is transferred as the collateral security for the repayment of debt, like securities, jewelry, or negotiable warehouse receipts, and these can be used by the borrower. The legal possession is passed, but they are still used by the borrower. They can still have the jewelry or the gold. So the best example of pledge is against gold jewelry. All right. So the person whose goods are bailed is called the pawner, and the person who takes the goods as security is known as the pawnee. This is the pawner-pawnee relationship, which is similar to the bailer-bailee kind of relationship, the bailment of goods for the purpose of providing security. So a special interest in the movable properties pledged passes to the pledgee by the virtue of bailment, but the ownership remains with the pledger. The ownership is still with the pledger. The pledger can use it. They can use it. And if the debt is not repaid, then the pledgee or the pawnee can make a sale of it. All right, they can have the right to take away the goods or its price. This is the pledge. Then we have hypothecation. Hypothecation, wherein the charge is created upon any movable property. In mortgage, we studied the charge was created on the immovable property, but in hypothecation, it is made upon any movable property. Now, a very important question that has been asked in the previous examination, under which act hypothecation has been defined? So, this term came to be defined in the Surfacy Act of 2002. So, hypothecation means the charge created upon any movable property existing or future. Another difference, right? The goods can be existing or future, created by a borrower in favor of a secured creditor without delivery of possession of the movable property to such creditor. So there is no delivery of possession in hypothecation. As a security for creating the financial assistance includes floating charge and crystallization. This, the difference between fixed charge and floating charge, and what is the effect of crystallization or the floating charge changing into a fixed charge, we will be seeing in the next chapter, where we study the charge, registration and non-registration of charges. All right. So what is happening under hypothecation? Basically, the hypothecation, it is different from mortgage. Although the immovable property is kept here, the mortgage relates to the immovable property, hypothecation relates to the movables. And in the mortgage, there is a transfer of interest in the property, but hypothecation involves only an obligation to repay the money, and there is no transfer of interest. Only an equitable charge is created in favor of the lender or the creditor, right? So there is no transfer of property. That is why this hypothecation is limited only to the respectable customers, because it is only an equitable without any possession. So if a question is asked why or in which type of charge only the facility is limited to the respectable customers, so we know it is hypothecation. Why? Because it involves only a charge, an equitable charge being created without any transfer of possession. So where can hypothecation be used? Let's say when the loans are raised against work in progress, or we will say if a particular person A has a factory or a showroom of any goods, let's say car, and at any time 20 lakh worth of cars is always there. So the bank can say you can continue with your usual business of buying and selling cars, but on this minimum level which is always maintained, we are creating a hypothecation. So it is ongoing, a work in progress. For example, rice mills, oil explorers, etc. Right? And it is convenient. Then we have the banker's lien. Banker's lien, it is the right of the banker to retain possession of the goods and securities owned by the debtor until a debt due from the latter is paid. So it is an implied pledge. Basically, the banker acquires the right to sell the goods which came into his possession in the ordinary course of business in case a debt is not paid. Let's say the person A had taken a loan from the bank, any bank, let's say bank ABC, and at the same time, they had also kept their money in a deposit account, in a deposit account. So the bank will have a right on this deposit account if there is a non-payment of debt, a non-repayment of debt. So the banker has absolute right on a general lien on all the goods and securities that are received by the banker. So the bank can then recover the amount, right? So that is a banker's lien. That is a banker's lien. So the banker, now this term that is given here, they are acquiring the right to sell the goods which came to his possession in the ordinary course of business. So if a customer by chance they leaves a packet containing certain share certificates or life insurance policies or fixed deposit receipts while they're leaving the bank premises, then the banker will have no right of lien. Only through the normal course of business they can create this right. So the property must come into the hands of the bank in normal course of business. Then it should not have been interested for any particular purpose. This possession should be lawful. So this is the banker's lien. And then we have finally set off. What is set off? Basically what we are doing, we are cancelling out. So it is the right of a debtor to take into account a debt owing to him by a creditor when claiming a debt due from him to the creditor. What is happening here? The right of a debtor to take into account a debt that is owing to him by a creditor. So if A and B, they have taken loan and given loan to each other, then they can cancel it off. So in the case of a banker, the right of set off enables him to adjust the debit balance in the customer's account with any balance outstanding to his credit in the books of the bank. So the banker can adjust his claim from the amount that is payable to the customer. Now here what is happening? In the banker's lien, the right was there that the bank can sell off any goods that were entrusted with him in the ordinary course of business. In the set off, the bank has the right to offset or detect a debt that is owed. Right? They can offset or deduct a debt that is owed. So the loan account and the deposit account can be set off. They can be set off. This is the meaning of a set off agreement between a bank. Now, the bank or the creditor, they cannot use both the rights together. They can either use the lien, banker's lien, or the set off. They cannot use both of them together. Also, the debt that is occurring due cannot be set off that against a debt that is already due. Plus, the credit balance in the account cannot be set off against a contingent liability. And whenever the account cannot be debited until the demand is actually made late or the due date has actually arrived. So these are certain conditions or salient features of a set off. However, automatic right of set off also arises if, let's say, there's the death of the customer or insanity or insolvency, on the insolvency of a partner of a firm or winding up, or on the receipt of a garnishee order or assignment of a customer's credit balance. Here the automatic right of set off will be given to the creditor or the bank. The unit 14 from module B. This unit is the creation, registration and satisfaction of charges. Today we are going to study the meaning of charge, the registration of charge, the different types of charges, what happens if you don't get the charge registered and so on. Now let us start. First we will see the meaning of a charge. First, charge has been defined in which act? So it is defined in the section 2 subsection 16 of the Companies Act 2013. Whenever the definition or we will say the act is mentioned, we need to remember it. Then a charge means an interest or a lien created on the property or assets of a company or any of its undertakings or both as security and includes a mortgage. So we already know that whenever a borrower takes a loan from a creditor or let's say a bank in our case, then in return of this loan they're giving this security as an interest to the bank that the bank have an interest on. They can sell it or they can recover their loan in case of non-repayment or in case of default. Now what will happen? Why this concept of charge is given? If let's say the borrower takes this security, if they had not given the possession and they had only created let's say a mortgage with a deposit of title deeds, they can again get it secure, they can again get the loan on the same security or the same property from another lender, let's say from bank A, then bank B, and then bank C, right? Now in the situation if the borrower defaults on the payment of the loan, so all of these lenders can come and ask for the repayment. Now who will be repaid when the security is brought to the market? This question might arise. So to solve this situation or to ease this question, what was done? The concept of charge and getting it registered was created. So doesn't matter when, but whenever the security is taken for the loan that is given by the bank, they have to get it registered. And when a charge is registered, it doesn't matter if the borrower gets it, the property, gives it for security to another bank or another lender. If the charge has been registered, then the priority of the repayment when it is marketed will be to the creditor who has gotten it registered, right? So this is the main aim of getting a charge registered. All right. So charge includes the meaning we have already seen, either an interest or lien created by the property. Now the most important topic of this chapter, it is mandatory for every company to register with the registrar of companies, the ROC, specific charges that are created by it on its asset as well as modification of the charge or its satisfaction. So three things are there. There are different forms that have to be filled and submitted to the ROC. When first the charge is being registered, it is the responsibility of the company to get it registered. Company who is taking the loan. But there are provisions under this as well, that if the company has not gotten the charge registered, then the bank can also get it registered. If they, however, do not, then again they will not get the priority in time of the repayment when the company makes a default. Second, for any change, if let's say the interest rate change is there or the due payment change is there, there is a change in the contract deed between the creditor and the debtor. And finally, when the charge has been satisfied or the loan has been repaid, then also a form has to be submitted. And all the companies, whenever they are taking a loan, whenever they are creating a charge on their assets or their property, they have to get it registered with the ROC. This ROC, when they register the charge, they are going to give a certificate, and it is believed that the charge is registered in the public notice. Public notice. Now, if we want to check whether a company has created a charge or already taken a loan on a particular asset or property, we can go to the MCA website. There's a portal for checking the charge, and we have to see through that. If, however, any bank, they do not make this clarification, or the creditor, they do not check whether the property is encumbered or not, then it will be their fault, because once the ROC gets the charge registered, they give a certificate. They believe that now this is in the public knowledge. The notice is being provided to the public that the charge has been registered. So the registration of charge provides a notice to the public contemplating to give credit to the corporation on how far the property of the company is encumbered. So now it is the responsibility of the creditor to check on the MCA website. Then, all right. Earlier in the uh, earlier law of the company law, it was given certain charges were mentioned that had to be required to be filed with the ROC, like charge for the purpose of securing any issue of debentures or the share capital or the book debts of the company. This act said that the 1956 Companies Act said that all the charges were not required to be filed with the ROC. But the new law, the Companies Act, has said that now all the types of charges are required to be registered with ROC within the stipulated time period, irrespective of whether the charge is created within or outside India, whether it is on the property or assets or any of its undertakings, whether the charge is tangible or intangible, fixed or floating, it is situated in India or outside India. All the types of charges have to be registered with the ROC. This change has been made with the new law, right? So all the charges, however, there are three exceptions. The charges not requiring registration are corporate guarantee, any charge arising due to the operation of some specific law, or a hundi, which is a negotiable instrument. Other than that, all the charges will have to be registered. This is given under the Companies Act 2013. All right. So if a question is asked, which of the following is not required to be registered, you know it is only three. Other than that, all the types of charges have to be registered. Then we have the two types of charges. Two types of charges. When, let's say, a particular company, they have stored their produce or they've stored their goods in a warehouse. In a warehouse, and then a part of the warehouse or a part of their total inventory they're keeping as security. So the bank or the creditor is going to have the interest only on the specific property or the properties of the company which are provided as the security. So the fixed charge is also known as a specific charge. It extends over a specific property or properties of the company. So when a particular or specific property is given as a security for a loan, then it is known as the fixed charge, only on the property which is given as a loan. Floating charge, however, means it is general. So on all the property of the company, the floating charge is created. It is not specific. So it floats over the present and the future property of the company, right? Or it does not restrict the company. The company can assign the property to a third person as well by a way of sale or security, right? So these are the two charges, the fixed charge and the floating charge. So fixed charge is only on some specific property, whereas the floating charge, it floats over all of the property, and the company can still buy or sell. They can carry on with their normal ordinary course of business. They can deal with the property in any manner until the charge attaches, right? Until the charge attaches. Now, there are certain circumstances in which this floating charge can get crystallized or convert into a fixed charge. So, when does a floating charge become a fixed charge or a crystallized or attached charge? When a debtor company ceases to carry on the business or goes into liquidation, the company is winding up, or the debenture holder or the creditor in whose favor the charge is created intervenes by getting a receiver, then the floating charge will now turn into a fixed charge. And the floating charge may also crystallize on the happening of an event specified. If, let's say, in the starting of the charge deed it was mentioned that, let's say, after a year this floating charge will be converted into a fixed charge, it will be crystallized, then also it will change. What will be the impact of a floating charge becoming a fixed charge? So when a floating charge upon all the property or assets of the company becomes fixed, it constitutes a charge upon the property or assets. Now all the properties, when on all the properties the floating charge was created and now it is getting crystallized. So now on all the property the fixed charge will apply. Then all the property that is belonging to the company will come under the fixed charge. What will be the benefit for the creditor? It has the priority over the subsequent equitable charges or over the unsecured creditors. Now let me just clarify it once. Whenever, let's say, the borrower had taken loan from five different creditors, A, B, C, D, and E. All right, but the charge was created on the same property, let's say a house. All right, not let's say a house, let's say on the property of the company that is kept in the warehouse. All right, on the warehouse, but then the charge was registered only by the third third creditor or the third bank, or they had given the charge of a fixed nature. Then when the property is sold in the market under the SARFAESI or IBC, then the money that will be generated will be first used to pay off the debt to the third creditor who had gotten the charge registered. So this creditor who got the charge registered will have the priority over the subsequent equitable charges or over the unsecured creditors. So now C will become the secured creditor as soon as the charge is registered with the ROC. when we study the SURFACI Act, we will see the sequence. There are 8 to 9 points. The first, the secured creditor will be paid from the amount that is generated from the market. Then the unsecured credit, then the payment will be made to the officers that undertook the securitization. Payments will be made to the employees of the company. Then any charges will be paid. And then on the eighth or ninth or seventh number, there is the payment will be made to the unsecured creditor, right? So whenever a fixed charge is created or a charge is registered, this creditor will become the secured creditor and they will get priority over all the other subsequent equitable charges or over the unsecured creditors. So this is the whole concept of getting the charge registered. That is why the charge is registered, right? So any subsequent registration of charge will not hold any prejudice to the first person or the first entity that got the charge registered. So doesn't matter even if the third or the fourth person is getting the charge registered, whenever the charge is registered first will get the priority. Now, an ordinance was made in 2018. Before this ordinance, the charges that were created or modified, they had to be registered within a period of 30 days with normal fees. Then beyond 30 days to 300 days with normal and additional fees. Then again, additional 6 months were given, right? So these terms were very, we'll say, uh, not up to the mark, or we'll say that the registration of charge was not compulsory because these were very flexible, ranging up to 1 year, 6 months, and so on. But then the ordinance that was created after 2nd November 2018, the days have been fixed. Within 30 days of the charge creation or modification, if the charge is registered with the ROC, then normal fees will be paid after 30 days, but within 60 days if the charge is created. So 30 plus 30 days, normal fees plus some additional fees. After 60 days, but within 120 days, another 60 days are given, normal fees. But now when this amounts to 120 days, the charge cannot be registered. This was not there in the previous or before the ordinance in 2018, right? The charge could be created beyond these days as well. But now, after the ordinance, starting from 2nd November 2018, the charge can be registered only within 120 days, not beyond that. All right. So this provision is there. This is very important, the change that has been made. So if you are asked a question, the charge cannot be registered after how many days? It is 120 days. It is 120 days. All right. Then what else? Now here I have mentioned the different forms which have to be submitted to the ROC whenever we are getting the charge registered, modified, or when the charge is satisfied. So CHD1 is for the application for the registration of creation. CHD2 is for the certificate which is given by the ROC. Then 3 for the certificate of registration and modification, the particulars, memorandum, notice of appointment. Now here, what is important for the application for any delay? If there is a delay of the creation of the charge or getting it registered, then the company will have to submit it with the form 10, right? So the application for dealer has to be made with the registrar in form number 10, supported by a declaration of why such dealing was there, or such delay is not going to adversely affect the rights of any other creditors of the company. All of these things are there. Another very important provision which is given is that if the company has not gotten the charge registered, then what will happen? The ROC says that the banks or the creditor can also get the charge registered, and if any fees is paid, because fees is paid for the registration of the charges, it will be borne by the company. They can get it recovered from the company. All right. So this provision is also there. So that is all for today. We have completed the revision of this module. And now if you want to join us for the last minute revision, enroll now for the BRBL capsule batch. This batch is available both in bilingual as well as English medium. You are going to get 12 plus hours of live marathon sessions, downloadable class notes for your quick revision, 10 full length BRBL mock tests that you can access anytime, and the sessions will be during the non banking hours, so do not miss any of the live classes. This will be the best strategy for your last minute revision. If you haven't yet subscribed to the channel, so subscribe to the Oliveboard JIB CIB English Medium channel. Like the video, share the video, and on a daily basis, we are bringing these important sessions for you. So I will see you in the next session. Thank you so much and all the best.